Good afternoon and welcome to today's webinar on the latest changes to the immigration rules with Adam Pipe from No.8 Chambers. Adam is a barrister specialising in immigration, asylum and human rights law and is ranked by Chambers and Partners for immigration law in the Midlands. Adam provides regular updates on the law at training events and on social media. For those who haven't joined our webinars before, my name's Finn and I'm a Junior Compliance Officer at DG Legal. The slides from today's presentation will be sent over tomorrow, and a recording of the webinar will be available for 3 months. So if we run over or you need to leave, you'll be able to watch the rest at a time of your choosing. We are in webinar mode, so we can't see or hear any of you. The webinar is designed to be an overview, and I know Adam has a lot to cover over the next hour, so I'm afraid we won't be able to cover any questions that you may have. Over to you, Adam.
Brilliant. Thank you, Finn. And a big thanks to Finn and Georgia for running today's session. And thank you to David and DG Legal for again supporting my training event. So today, my title is More Changes Are Coming. And we're looking at the latest changes to the immigration rules. Because in immigration law, the only constant is change. So you've got my slides in front of you. My name's Adam. I'm a barrister specialising in immigration, asylum and human rights law. I'm based here in the Midlands, but I cover cases across the country and I do training events across the country. As Finn said, the slides will be available and will be sent out. So don't worry, you will get a copy of the slides. We'll also make the recording available. Both DG Legal and I put these events on for free. Neither of us charge anything. So what I'd encourage you to do, there are, I think, over 800 people registered for the webinar today, which is amazing. But have a click on that top link and you'll find a number of chosen charities that DG Legal support. And I'd encourage each one of you, even if it's just a couple of quid, to make a donation as a sort of thanks for the webinar, and we can make a huge difference to some worthy causes. So have a look there for the slides, the recording, and to donate to the charities. DG Legal offer a number of services to lawyers, immigration lawyers and non-immigration lawyers, in terms of compliance, marketing, accreditation, supervision. And I'd encourage you to reach out to DG, tell them you were on this webinar today if you're interested in getting them supporting you. Perhaps you want to get your firm into the Legal 500 and you want their consultancy services to help you do that. So do reach out to DG Legal as a result of that. This is the good point in the webinar to get your phones out. Do scan my QR code or click on my link tree there. You'll find links to my free resources. There's the Telegram channel. There's the WhatsApp channel. I know sometimes people struggle with joining a WhatsApp channel. You join it, but then you've got to click the link that either says join or subscribe to the channel. There's links to the YouTube videos, to my in-person events. I know this year I've got an in-person event coming up in London in December. And also for other webinars I'm doing. Next week, I'm doing a webinar covering the key upper tribunal case law, the reported cases of this year so far. We're going to look at things like evidential flexibility, deprivation of citizenship, withdrawing Home Office decisions, drafting permission to appeal grounds, and lots more. So if that's something that's of interest to you in your practice, I'd encourage you to sign up. So lots of free resources there. I hope you find them helpful. So what am I going to cover in our hour together today? Well, first, the backdrop. And the backdrop to the changes is the government's white paper. I'm not going to go over the white paper. I've done that before, but I'll give a quick summary in relation to that. Secondly, then, we'll look at the 3 main statement of changes we've had since the summer. I covered the July changes in my previous webinar, so we're going to look at the last 3 statement of changes, the one from August, the one from September, and the rather big one from October. As a bonus, we also saw draft legislation in October in relation to the increase in the immigration skills charge. So I'm going to briefly touch upon the immigration skills charge amendment regulations 2025. So that's where we're going today. So the government's white paper. The government published their white paper in May of 2025, and the link is on the slides to the white paper. And at paragraph 6 of the white paper, the government said this: "It is this government's intention to restore confidence in the immigration system so that we can support and see benefits from migration while ensuring it is properly controlled and is not used as an alternative to fixing problems here in the United Kingdom." That is what this white paper seeks to achieve. And a number of changes, a big number of changes, were announced within the white paper. Paragraph 27 of the white paper gave a summary of 5 big changes. They are increasing the threshold for skilled worker visas to graduate level, so we reduce lower skilled migration. Only allowing a narrow list of critical shortage occupations onto the temporary shortage list, alongside workforce strategies to increase training and participation rates in the UK. Closing the social care visa route to overseas recruitment. Restricting dependents for lower skilled workers on the temporary shortage list, and increasing salary threshold for all visa holders seeking to bring in dependents, and increasing English language requirements for visa holders and dependents. Now, for more on the white paper and for the July big statement of changes, have a look at the webinar I did for DG back at the start of this term, back in the beginning of September, called Back to School. What I've put on the slide there is a link to the YouTube video, to the audio if you prefer to listen on Spotify, and to the slides from that webinar. But we cover all of that and the white paper in that Back to School webinar. But what changes have been introduced so far from the white paper? CJ McKinney and the team at the House of Commons Library have produced a research briefing. They produced that on the Tuesday, the 14th of October. And it summarises like this. It says, "There is no overall timetable for the white paper proposals to come into force." And I know that a lot of our clients have been worried about the changes to indefinite leave to remain. That's going to go out to consultation later this year, and there was a statement in relation to that announced, but no overall timetable for the white paper proposals to come into force. What changes have come in so far? Well, we've seen the initial reduction to the list of jobs eligible for skilled worker visa sponsorship from the 22nd of July this year. We've got the revised shortage list in place until the end of 2026, with a migration advisory committee reviewing which medium skilled jobs should be on the list beyond that. We've also seen from July of this year, 22nd again, the end to overseas recruitment of social care workers. Now, in these last 3 bullet points, these are things we're going to cover today. So graduate visas only lasting 18 months for applications on or after 1st Jan 2027, but still 36 months for PhD. New applicants for skilled worker scale-up and high potential needing B2 English, up from the current B1 from the 8th of January 2026. And some liberalisation of the high potential and global talent routes from later this month. In addition, regulations to increase the immigration skills charge will begin their parliamentary approval process later this week. And I'm going to cover those draft regulations that were laid. But be aware, a new framework for family visas is due by the end of 2025. Really helpful briefing paper. I don't know if CJ's on today, but thank you to CJ for that. Do have a look at it and the links on the slide. So we're covering 3 statement of changes, two quicker ones and then the big one from October. Let's look at the first one from the 5th of August, and that was CP 1373. I've given you the link, and for all of them, I'll give you the link to the statement of changes and to the explanatory memorandum. And a lot of time in my slides, I'm quoting from the various explanatory memorandum. The statement of changes from the 5th of August 2025 introduced as a result of the government's one in, one out agreement with France, Appendix UK European Applicant Transfer Scheme. And that appendix set out who is eligible for this scheme and how they apply for it and the requirements that must be met. This scheme is only open for a time-limited application window and is restricted to those in France at the time. It allows for adults and family groups of parents and children from all nationalities, but excludes nationals of EEA member states or those who enjoy free movement rights as a family member of an EEA national. And they can express an interest, it's an expression of interest in coming to the United Kingdom. Those whose application is approved and who meet the security checks will be able to come to the UK for 3 months to consider how to regularise their stay in the UK. So this is an extract from the appendix itself. So the Secretary of State will transfer a limited number of people from France to the UK. The total number of people transferred to the UK will correlate with the number of people who are removed from the UK under the pilot arrangement on the prevention of dangerous journeys. So we are talking small numbers here. Applicants must be aged 18 or over at the time they submit their application, unless they're applying with a family member who is aged over 18. It's a two-stage process under the scheme. The first stage is the expression of interest. So application windows for expression of interest applications will be set. The Secretary of State will determine at that application window, and if you submit an application outside an application window, it will be rejected. If you make an expression of interest application from outside France, it will not be considered. If it's made from within France, the Home Secretary will decide which expression of interest applications will proceed to stage 2, which is entry clearance, in line with prioritization criteria set out in the guidance. And I'm going to cover that prioritization criteria in a minute. Any outstanding expression of interest applications at the time the pilot closes will then be rejected. So if an expression of interest application is selected, the Home Office will then complete an application for entry clearance on behalf of the applicant. And then the entry clearance application will be considered against the requirement in the rules. And the Secretary of State can pause at their discretion and close the scheme when the volume required has been reached. You can't use the scheme to apply for leave outside of the rules. I wanted to provide some resources for you. So there's the guidance in the top link. The second link is the application form. And the third link is the caseworker guidance for this scheme. And I wanted to take you to the caseworker guidance briefly to look at the order of consideration that is given in the expression of interest stage under this appendix. So expression of interest applications must be selected for consideration according to a 3-stage selection process. This ensures that individuals most likely to be targeted by smuggler and trafficking gangs or able to remain in the UK and those with a connection in the UK are prioritised for consideration under the scheme. So the selection process, stage 1 is for high grant and high volume nationalities, and those high grant and high volume nationalities are defined within this guidance. Stage 2 is a connection to the UK, and stage 3 is the lottery. That's the random selection, and each stage must be taken in turn. So applications which satisfy the criteria at stage 1 will be selected at random for consideration against the validity requirements of the scheme. Applications which satisfy the validity requirements will then be considered against stage 2 of the selection process. If an applicant satisfies the criteria of stage 1 and stage 2, the application selection process and the validity requirements of the scheme, it must be prioritised then for biographic checks. Applications which pass the biographic checks may be progressed to the entry clearance stage, or the assessment of the family connection for individuals who applied as part of a family group. If an application does not satisfy stage 2, the application will be selected at random with all other applications which satisfy stage 1 of the application selection process and the validity requirements, once all the applications with a connection to the UK have been considered. If there are no applications which satisfy stage 2 of the selection process, or all the applications which satisfy stage 2 have been progressed to the entry clearance application stage, you must select at random any applications which satisfy stage 1 of the selection process and the validity requirements of the scheme for biographic checks. So it seems like if you meet stage 1 and stage 2 and satisfy the biographic checks, you go forward to entry clearance. If you only satisfy stage 1, you're in that random selection. So that was the first statement of changes in relation to that scheme. Second stage statement of changes included the big change of the pausing of new applications under Appendix Family Reunion from the 4th of September 2025 at 3 p.m. So I'm sure a number of you were scrabbling around before that time because this was trailed that it was coming to make those applications under the old provisions. So what they say is, given the immediate pressures that result from family reunion, we are therefore introducing a temporary pause to Appendix Family Reunion Sponsors with Protection as we undertake a full review and reform of the current family rules to ensure we have a fair and properly balanced system. Extant applications will continue to be considered under Appendix Family Reunion Sponsors with Protection rules in place prior to the commencement of the suspension. So if you got your application in prior to 3 p.m. on the 4th of September, it will be under those previous provisions. However, what they have done is made changes to Appendix FM. So 5.4, Appendix FM has been amended to allow applications from a partner and dependent child of a person with protection status in the UK. But here's the stinger, of course, bringing it in with Appendix FM. In line with other applications under Appendix FM, a person will need to pay the fee or obtain a fee waiver and meet the core requirements of the route. For example, English language and financial requirements. Now I'm going to just pause here. I did some training sessions similar to the one I'm going to do in London in December, in Birmingham and Manchester recently, and we were discussing this, and people were saying they have, for those who didn't get their applications in prior to the 4th of September, they are making applications under Appendix FM, applying for a fee waiver. Obviously, this all takes time, and then applying under Appendix FM, relying on Gen 3.2, arguing unjustifiably harsh circumstances, but makes it very difficult indeed. 5.5, the Appendix FM rules require the parent of a dependent child to have sole responsibility where the child is not accompanying or joining both parents in the UK, which is different from the approach under Appendix Family Reunion. The policy intention is to ensure that where both parents have parental responsibility for a child, the child remains with the parents to ensure the UK is not brought into custody battles and a child is not brought to the UK against the wishes of the other parent. However, where an applicant is unable to demonstrate sole responsibility under FM, the child will still be granted permission if there are serious and compelling family circumstances that make exclusion of the child undesirable. A lot of us will be familiar with that test and the sole responsibility test. If you're not, have a look at TD Yemen for sole responsibility, and have a look at the case of Mandiba for serious and compelling family circumstances which make exclusion undesirable. This was the written statement of Parliament that came out with these statement of changes. So the new rules provide for a temporary suspension of new applications for refugee family reunion and for refugees to be covered in the meantime by the main family rules that apply for other UK residents and British citizens, with plans for new reformed arrangements to be put in place at a later date. The current rules for family reunion for refugees were designed many years ago to help families separated by war, conflict, and persecution. But the way they're being used now has changed. Currently, there are limited conditions on family reunion for refugee sponsors, unlike those in place if the sponsor is a British citizen or settled in the UK. A refugee sponsor does not have to prove they can financially support or accommodate their family. In the immigration white paper, we said that we will set out a new family policy before the end of this year. So it's coming, the new family policy, before the end of the year, which will cover all UK residents, including those who are British, settled on work routes, or those with protection status seeking to bring family members to the UK. Noting the immediate pressures that result from family reunion, particularly on public services and local authorities, we're introducing a temporary pause to appendix family reunion sponsors with protection as we undertake a full review and reform of the current family rules to ensure we have a fair and properly balanced system. Problem with that is the whole point of family reunion recognises that refugees are not in the same position as a British settled or somebody on work route. They've had to flee a situation of persecution, and they're then separated not by choice from their family, but by necessity. And there are these special rules in place for them. So that's my difficulty. I don't know if there are challenges in relation to this suspension. It may be that people are waiting to see what comes later this year. But the amendments to Appendix FM are set out there within this written statement. And again, 3 p.m, 4th of September, any applications before those were under the previous provisions. So those are the two short statements I wanted to highlight. There are other consequential changes in those statements, but I wanted to cover those big, the one in, one out policy and the transfer scheme, and then the pausing of family reunion applications and the need for then applications under Appendix FM in the meantime. Thirdly then, and where we're going to spend most of our time today, is on the recent statement of changes HC 1333 from the 14th of October, so last month. There's the link to it, and I've given you the link as usual to the explanatory memorandum. So what changes are set out within this statement of changes? Well, 4.2 of the explanatory memorandum gives us a bullet point list. So there's an introduction of a visit visa requirement for nationals of Botswana. We've seen a lot of that over recent years with countries then identified, and in the next statement of changes, they're put on the visa national list. A change to the visa national list, which accords with the recognition of Palestine. We're going to look at German school groups and an easing of travel requirements for them. A change to validity requirement in Appendix temporary permission to stay for victims of human trafficking or slavery, and an introduction of dependents for stateless peoples, an amendment to Appendix statelessness, and some important points I want to bring out there. And then these next bullet points are white paper points. So the change to the English language requirement for the economic routes, an expansion of eligibility for high potential individuals, the reduction in the duration of stay for graduates, a provision to allow students to transition in country to the innovator founder route, a big change in terms of suitability and the replacement of Part 9 with a Part Suitability, and then changes to align the family and private life rules with the common suitability rules. So changes to FM, private life, Appendix ADR, Appendix settlement, family life. So where those rules had their own suitability requirements and particular carve-outs, which were sort of more generous than the general grounds for refusal in Part 9. Now Part Suitability will apply to those. Changes to Appendix Temporary Work in relation to seasonal workers, concerning the number of months a seasonal worker must be outside the UK before being permitted to apply for a new seasonal worker visa, and changes to the Ukraine Permission Extension Scheme in relation to safeguarding measures. So there's just a brief overview. So we had a written statement to Parliament. So that's set out there that they're introducing a visa requirement for all visitors from Botswana from 3 p.m. on that day. So we've commonly seen with these countries being added to the visa national list, that will often come in at 3 p.m. on the day the statement of changes is laid. There is a 6-week visa-free transitional period for those who have a confirmed booking and an electronic travel authorization. So that carries on until 3 p.m. on the 25th of this month, November 2025. Then we're seeing this targeted and capped expansion to the high potential individual. And that is those who've graduated in the last 5 years from the top universities, and they've doubled the number of eligible universities whose graduates can use that route. Remember, that's not about nationality, it's about which university you went to, and it's capped at 8,000 per year. Provision, as I've said, setting out that students can transition to the innovator founder route. This is sort of trying to keep entrepreneurial talent in the UK and allow people to build their business with a smooth transition within the UK. Then we see the reduction of the graduate route. Good thing is that PhD graduates have been kept at 3 years. So everybody else down from 2 years to 18 months, graduates still at 3 years. And then these big English language changes from B1 to B2 for skilled workers, high potential individual, and scale up routes. And we have different implementation dates, which I will cover as we go through things in detail. Do you know, this was the press release that came out, and it was entitled, "Migrants will be required to pass A-level standard of English." So, you know, the government trying to be all tough with their press release. Ridiculous to post it like this, but there it is. So what they say there is, from today, we've introduced these new tougher English language requirements, which are A-level equivalents. They also set out that graduate visas will be cut, and then this increase in the immigration skills charge. So as I said, as a bonus, I want to cover those regulations. So first time since 2017, it's gone up. It's gone up by 32%, so a significant increase. So for those of you who work with sponsors or who are sponsors, something to be aware of. And they say this will boost investment in British workers and reduce reliance on overseas recruitment. And the parliamentary process to increase the charge will begin later this week. So that was then the laying of the regulations. Increasing in financial requirements for students. So student maintenance has gone up, and we'll have a look at that. But they also, even though it's entitled "Migrants Required to Pass A-Level Standard of English," they also announced the positive changes in terms of attracting more highly skilled talent to the United Kingdom. So we have the expansion of the high potential route from the top universities, capped at 8,000, although the number of people expected to come is to double from 2,000 to 4,000. So 8,000 like sounds, oh, we're bringing in 8,000 high potential people, but actually they're expecting it only to go up to 4,000. Again, they're promoting this transition from student to innovator founder, and we'll have a look at that. Enhancements to the global talent route, and that's particularly in regard to expanding the prestigious prizes. And if you've not looked at global talent, do check that out as an alternative route. I recently talked to Sabina Kauser on my YouTube channel, and we did a video about that. I'd encourage to go back on my YouTube channel, watch the discussion we had about global talent as an option. Because the aim of the government is to double the number of highly skilled people coming to the UK on their highly skilled routes. So here are the regulations. So this is the bonus bit today, the Immigration Skills Charge Amendment Regulations 2025. So this is draft legislation due to come into force on the 16th of December 2025. I've set out there the explanatory note which says that these regulations are made under the 2014 Act, amend the Immigration Skills Charge Regulations 2017. The 2017 regulations provided that a sponsor, subject to certain exemptions, must pay a charge each time that it assigns a certificate of sponsorship to a skilled worker. Regulation 2.2 of these new amendment regulations updates the exemptions to the requirement to pay the charge in order to align with the latest standard occupational classification codes which are used by the ONS. And then Regulation 2.3 of these regulations increases the amounts of charges payable by sponsors by 32%, and there's a table within the regulations. Here are some of the key changes then to be aware of. The new rates apply to certificates of sponsorships assigned on or after December the 16th, 2025. 32% increase. So for medium and large sponsors, it's gone up from 1,000 to 1,320 per year. For small sponsors, up from 364 to 480. And then if you want longer, it incrementally goes up in each 6 months by 660 or 240, and have a look at the table in the regulations. Some occupations are exempt from the charge, such as those in certain PhD level jobs and certain scientific roles, and certain other codes are added. The LexisNexis article I refer to, the first link on the slide, is where I got those extra codes. But note my last bullet point. Employers, and if you work with employers, if you're an advisor who works with employers, they need to review their sponsorship plans and their budgets in light of these increased costs, because it's nearly a third increase, and consider whether causes can be assigned before the 16th of December to secure the current rates. The final link on this slide is an article by Lewis Silkin Solicitors, and I think that has some really helpful recommendations for action sponsors should take. So have a look at that. So let's go back to this statement of changes then, 1333, and have a look at some of the substantive changes that I've outlined already. So we've seen this introduction of a visit visa requirement for nationals of Botswana. Why are they doing this? Well, they think there's a high number of people traveling, look at 5.4, from Botswana as visitors for reasons not permitted under the immigration rules. And they think there is too high a number of people claiming asylum. And this is the same rationale we've seen for other countries that have been put on the visa national list over recent years and in recent statement of changes. So they say since 2022, there's been a high number claiming asylum. Between 2022 and 25, 1,332 nationals, and nearly half of those, 642, were made at port. And January to June this year, we've seen 147 nationals of Botswana claiming asylum. But again, to make things fair and to avoid operational difficulties, they have this 6-week transition period for those with a confirmed booking and an ETA. Obviously, if it's after the transition period, your clients will now need to apply for a visit visa. So that transition period ends at 3 p.m. on the 25th of November, 2025. So that's the introduction of a visa requirement for nationals of Botswana. We've seen a change to the visa national list due to the recognition of Palestine. So in September of this year, the UK announced a formal recognition of the state of Palestine. As a result of that, Palestine is now added to Immigration Rules Appendix Visitor at Visa National List. So that appendix which lists the visa national countries. So nationals of Palestine will need to apply and obtain a visa before visiting the United Kingdom. And they've also made amendments to the Immigration Passenger Transit Visa Order 2014. The amendments in relation to Palestine nationals come in on the 11th of November of this year. What about our German school groups? Well, what happened is, as a result of Brexit, there was a need for people to travel with a visa. But look, the requirement to travel, 5.15, the final or penultimate sentence, the requirement to travel on a passport and hold a visa was viewed by Germany as a significant barrier to German school groups visiting the UK. The changes address this concern. So this change will allow people aged 19 and under who are studying at a German school or educational institution, the existence of which is confirmed by the relevant German municipal or competent authority, to come to the UK without an advance permission, an ETA or visa, when they're travelling as part of a school party of 5 or more. It also allows EU, EEA and Swiss nationals aged 19 and under who are studying at the school to travel on a national identity card rather than a passport. And it mirrors a similar arrangement the UK has with France and is part of the UK-Germany treaty. Implementation date for this one, 11th of November. So then the changes in terms of Appendix Temporary Permission to Stay for victims of human trafficking or slavery are set out there in 5.17. I don't propose to go to those in any detail. The introduction of dependence to appendix statelessness. This raises some important issues I want to flag up and may need you to take some urgent action and make some urgent applications. So changes are being introduced. So a partner or a child of a stateless person may apply for entry clearance or permission to stay under appendix statelessness from the 11th of November. But listen to this bit. Where they formed part of the family unit before a stateless person was granted permission to stay. So they've got to be pre-permission family unit. Those applying as a dependent on this route will need to meet the relevant partner or child requirements. However, where a partner or child of a stateless person are not themselves stateless and form part of the family unit after a stateless person was granted permission, they may apply to come to the UK under the family provisions in Appendix FM. And that involves, of course, paying a fee or a fee waiver and meeting the relevant requirements. This comes in, as it says, from the 11th of November. However, because of the judgment on the 14th of February, Mr. Justice Jay in the Administrative Court in the asylum aid case, until the 11th of November, dependents are considered under the old paragraph 410 and 411 of Part 14. And I've put the archived rules there, and the guidance sets this out because of this judgment. And these provisions are far more generous because they're not restricted to family units before a stateless person was granted permission to stay. And they also have no requirement for maintenance and accommodation. So it may be that if you've got somebody who wants to apply stateless and wants to apply for their dependents, you need to make an application before the 11th of November under the old 410 and 411. There is a really helpful article which also points out some of the errors in the new rules on free movement. So I'd encourage you to look at the free movement article and to look at those rules, but just be aware of those changes and the difference between the new provision under the appendix and the old 410 and 11, and which as a result of the decision in asylum aid still apply. What about the changes to English language requirements for economic migrants? Well, this was something set out in the white paper. So the English language requirement is changing for skilled workers, high potential individuals, and the scale up routes from B1 to B2. But look at the transitional provisions in relation to this. This new requirement will apply to those seeking an initial grant of leave in a relevant route following the implementation of these provisions on the 8th of January 2026. So new applications from 8th of January 2026. Those who've already obtained a permission where they were required to show a B1 level will continue to be subject to the B1 level when they're seeking an extension on the same route. So if you're working or you're a sponsor, you're working with people who are skilled, want to apply as skilled workers, high potential individuals, or scale up routes, need to make sure people are preparing themselves if they're going to make their first application from the 8th of January, because it is an significantly increased level. I did some Googling around, and this is what I came up with in italics when I did my search. So B2 is an upper intermediate level of English, where a person can understand the main ideas of complex texts, produce clear and detailed writing, and interact with a degree of fluency and spontaneity with native speakers. Most of the time, I can't do that. This level can be considered a confident level of English. So notice it is a significant jump for those people. And 8th of January is not far away, so people need to be getting themselves into that position where they can obtain a B2 qualification. Then the high potential individuals, this targeted and capped expansion. So we've seen an increase, a doubling of the eligible institutions. Capped at 8,000, but as I said earlier, they only anticipate they're going to get to 4,000. This came in this week, so a couple of days ago, from the 4th of November. So the government have now published the high potential individual visa global universities list for 2025, and they've updated 2020 to 2024 and removed 2019, because remember, you've got to have graduated from one of these institutions in the last 5 years. I've stuck the link for the 2025 list, and there's a really helpful article on Vanessa Gwangwyn's site in relation to this, and looks at the benefits of the visa and also the different universities. America dominates, then it's China. I think there are some Hong Kong ones, Canada, some European ones. The Southern Hemisphere is only represented by Australia. So you can see the focus of those universities. But obviously it doesn't depend on your nationality, it's of graduating from those universities. To remind people, like this week, I put an image on social media which reminds people about the high potential individuals. So if you go on my LinkedIn or my Telegram or my WhatsApp channel, you'll see this image. So it's permission to stay for 2 years, or if a doctorate, 3 years, if you've been awarded a qualification by an eligible university in the last 5 years. It doesn't count towards settlement, but you can work in most jobs. You can look for work, be self-employed. You can bring dependents, do voluntary work, and travel and return. And it's the qualification must be equivalent to a UK bachelor's, postgraduate, or doctorate awarded in the last 5 years. So have a look at the high potential guidance, and the link is at the bottom of that image. Then we've seen the change to the graduate visa. Obviously, educational institutions, one of the benefits for them in attracting foreign students to the United Kingdom is the graduate visa. But the government has reduced the time from 2 years to 18 months. But the positive thing is that PhDs will still get 3 years. Obviously, the majority of people are not PhD graduates, though. This applies to applications submitted on or after the 1st of January 2027. So there's a good bit of lead time in relation to this for those coming towards the end of their studies and wanting to apply for a graduate visa. But from 1st of January 2027, generally down to 18 months, but PhDs with the 3 years. I've again put an image online, which I've shared, and again, feel free to use this image. Please don't change it, and you can post it to tell people what the changes are. And again, if you look at my Telegram, my WhatsApp, and my LinkedIn, that image is there. What about these students going over to the innovator founder route? So this changed the student work conditions that will allow student visa holders to establish a business where they've completed their course and are switching to the innovator founder route. It replaces a similar provision that previously applied to those switching into the startup route, which is now closed to new applications. Big date for this one, 25th of this month, 25th of November. Helpful article on the Smith Stone Walters website. So what you need to do in order to switch is have successful completion of your course of study for which your CAS was issued, valid student permission at the time of application without any overstays. Remember, you've got to have an endorsement from an endorsing body confirming that the idea is innovative, viable, and scalable, and that you will play an active role in the business. There's no fixed minimum investment required, but you need to demonstrate sufficient funds to support the proposed business, and you need a B2 level of English proficiency. But in this article, Smith Stone Walters say this: under the new rules, students who apply to switch before their student permission expires can immediately begin self-employment, effectively legalizing their entrepreneurial activities during the transition period. Their existing visa status will remain valid, obviously through 3C, until a decision on their application is made, providing a seamless pathway from study to business ownership. So those of you who work with student migrants, perhaps you work at the universities, this may be something you can advise people that is an option for them. Now, one of the big changes I want to cover before we finish today is this replacement of part 9 with part suitability. So this is now the central reference point for all suitability related refusal and cancellation grounds. Interestingly, the famous paragraph 39E of the immigration rules, which is the exception for overstayers, has been moved into part suitability under a dedicated section titled exception for overstayers. So a number of changes in the rules have been made, so it cross refers to that. But various family and private life routes have often had their own suitability criteria, which were more generous, a sort of carve-outs. But now this is going, and Appendix FM, Appendix Private Life, Appendix Adult Dependent Relative, Appendix Settlement Family Life will need to meet Appendix Part Suitability, forgive me, from the 11th of November 2025. A really helpful article by Alex on free movement. Do have a look at this. And it gives some worked examples of the interrelationship between Appendix FM and part suitability. And Alex says this in the article: all of these changes take effect on the 11th of November 2025. Though all of the relevant category specific changes in Appendix FM do have transitional provisions that mean that an application will be considered under the provisions, the previous rules, forgive me, if lodged on the 10th of November 2025 or earlier. So in relation to Appendix FM, there are transitional provisions if you lodge 10th of November or earlier. But this is slightly confusing as part suitability changes take effect on the 11th of November 2025 without any transitional provisions. So come 11th of November 2025, part suitability will apply, even though under FM there are transitional provisions in relation to those provisions. Here is an extract from part suitability, and it sets out that this is how the powers to cancel or people's entry clearance or leave to remain or refuse is exercised. But where a person has settlement and is in country, not at the border, their permission can only be cancelled on the grounds contained in section 76 of the 2002 Act. But it does specifically say in part suitability, decisions on suitability are either mandatory, must, or discretionary may. So we're used to the language. But look, where a refusal under this part would be incompatible with the UK obligations under the European Convention on Human Rights, the route-specific rules set out the approach to be taken. So what they're saying is, well, yeah, you've got these part suitability, but you need to look in the routes themselves, which will set out what happens where it would breach human rights. And we'll come to that in a moment. So it's set out in 5 sections: the application of this part, the grounds for refusal or cancellation of entry clearance or permission, and then additional grounds in various categories in 3, 4, and 5. So let's look at part 1 and the application of this part. This part applies to all routes under these rules, except, and it rules out Appendix EU, Appendix EU family permit, the asylum rules, except certain asylum rules, Appendix service providers from Switzerland, and Appendix settlement protection. And then in 1.2, under certain provisions in A, B, and C, only certain bits of a part suitability apply. This part does not apply to Appendix electronic travel authorization, and 1.4 repeats that issue about those with settlement and section 76 for those in country in terms of cancellation. Let me give you some of the key provisions. As we just looked at, 1.1 is the application of the part. 1.2 to 1.4, we just looked at some of those are the exceptions. 5.1 to 5.5 are the criminality grounds. So be aware of the criminality grounds. And then there's this additional Appendix FM safeguarding ground now, which caught my eye. It says this: an application for entry clearance or Appendix FM must, so mandatory, be refused if the decision maker considers the applicant's parent or parent's partner poses a risk to the applicant. Importantly, 9.1 to 9.2 are deception grounds. Look at the different wording now of the deception grounds. And 11.1 to 11.8 are previous breaches of the immigration rules. Now, 11.2 is now the equivalent of what in old money was 320.11, then was changed to 9.8.2, and this is acting to frustrate the immigration rules. So it now is worded like this: an application for entry clearance or permission to enter may be refused, so still discretionary, where the applicant has previously breached immigration laws as defined in 11.4, and 11.4 sets that out. There's some number or lettering mistakes because there's 2 little a's. The second little a is those who's an illegal entrant. Somebody's emailed a question before the webinar saying, do you need to have been served an illegal entry notice for that? I don't think you do. And B, the application was made outside the relevant time period. So that's the re-entry ban. Didn't used to apply to those applying under FM. It does seem to do now. And the applicant has acted to frustrate immigration controls, and it cross-refers there to 11.7. So that's the wording there. In terms of that exception for overstayers, that's set out in 13.1 to 13.2. Those are only some of the key provisions. I did think that perhaps I should do a webinar in the future where we just walk through the new suitability appendix as a whole. If that's something of interest, get in touch with me. I'll look into doing that or doing a YouTube video on that. I wanted to give you a quick slide on the relationship between Appendix FM, Gen 3.2 and suitability. Because remember when I read the introduction to Appendix suitability or to part suitability, it said, well, if it breaches human rights, refer to the particular appendix of the immigration rules. So we know within Appendix FM, human rights are dealt with and Article 8 is dealt with in Gen 3.2. And in Gen 3.2, we're all familiar with it. It talks about exceptional circumstances which would render a refusal of entry clearance or leave to enter or remain a breach of Article 8 of the ECHR because refusal would result in unjustifiably harsh consequences for the applicant, partner, relevant child. But from the 11th of November, even if Gen 3.2 applies, it is still subject to provisions of part of appendix suitability. So it says in various rules where paragraph Gen 3.23 applies, but the applicant does not meet the suitability paragraphs in 2.1, 2.3, 4.1 or 5.1 in part suitability, the application on Appendix FM will be refused. So I've got them in front of me. 2.1 is exclusion, deportation order or travel ban. 3.1 is non-conducive grounds. 4.1 is exclusion from humanitarian protection or asylum. And 5.1 is criminality. So even if the decision maker is satisfied that it would breach Article 8 on unjustifiably harsh grounds, if you fall foul of 2.1, 2.3, 4.1 or 5.1, your application under FM will be refused. And that also applies to EX1 and the insurmountable obstacles or the children provisions within EX1. They're also subject to 2.1, 2.3, 4.1 and 5.1. So just be aware of the interrelationship. Changes to the appendix temporary work seasonal worker permit seasonal workers to spend no more than 6 months working in the UK during any rolling 10-month period rather than the current 12-month from the 11th of November. Some changes to the Ukraine Permission Extension Scheme, which was brought in on the 4th of February in terms of safeguarding and aligning leave of children with those of their legal guardian. Changes to global talent. The first part is in relation to architects. Prestigious prizes. Remember, you don't need an endorsement if you have a prestigious prize. They are very significant prizes, but they've expanded those by 27 and they've removed one prize because it's no longer awarded and there are no living former winners. So that would only help the dead. So they've removed that prize. 11th of November. Some changes to EUSS, mainly clarifying some points in regards to residents in the United Kingdom for settled status and cancelling pre-settled status. Some brief other changes which I've set out. And one to be aware of is the changes to student maintenance requirements for the 11th of November. So it increases that in line with maintenance loans. So it's going up to 1,529 per month in London. So that would give a 9 month of 13,761. And outside London, 1,171, giving a total of 10,539. So there are about 15 seconds to go until 2 o'clock. Here's the recap of the key dates. 14th of October for Botswana, high potential individual, the 4th of this month. Lots of changes on the 11th of this month. The transitional provisions or transitioning provisions for students going into Innovator Founder, 25th of this month. 16th of December, immigration skills charge, English language, 8th of January next year. 1st of January the year after, reduction in permission for graduate route applicants. It is 2 o'clock on the dot. Here's my final slide. Thanks, Finn, and thanks everybody for joining us.
Yeah, thank you very, very much, Adam, and thank you to everyone for joining us today. Again, sorry we didn't have time to answer your questions. And as a reminder, the slides and a recording of the webinar will be sent over tomorrow. This afternoon, you should receive an email asking you to rate the webinar out of 5 stars. If you've enjoyed it, please do leave feedback and any suggestions for future topics. We don't have any new webinars confirmed at the moment, but we will be announcing some for the start of 2026 shortly, so do look out for them. Thanks again for watching and have a good afternoon.
Thanks, everyone.
Thank you, Adam.